Good evening, everyone. Folks are still joining the webinar, so we're going to give it just about 30 seconds before we get started. Okay, well, welcome and good evening, everyone. We're really glad to be here. My name is Tony Wilkin Gibbard. I'm the Executive Director of Midwest Environmental Advocates. And many of you probably know Midwest Environmental Advocates is a nonprofit environmental law center. We combine the power of law with the resolve of communities facing environmental injustice. And we do that to secure the rights of all people to healthy air, land, and water. We've had just a remarkable level of interest in this topic and this webinar. So as I said, we're really excited to be here, and we'll get right into the program in just a minute here. I want to do some introductions. I want to introduce our staff. We have Senior Staff Attorney Rob Lee, who is here with us tonight, Anya Jansen, who is our Staff Attorney for Native Nations Partnerships, and Skylar Harris, who is an attorney and our Climate Justice Fellow. As I said, we want to get right into the meat of the program, so I'm going to turn the floor over to Peg Schaefer, our Communications Director. Peg, the floor is yours.
Thank you, Tony. I'd like to start by inviting each of you to think about the last time you enjoyed one of Wisconsin's lakes or rivers. Maybe you were boating on Lake Winnebago, or kayaking the Wisconsin River, or walking along Lake Michigan. Maybe you were swimming at Devil's Lake, or fishing a trout stream, or simply enjoying a picnic overlooking the water. Most of us never stop to ask why those experiences are possible. We simply take for granted the rights we have under something called the public trust doctrine. While to some of us that might sound like some abstract legal concept, the public trust doctrine is actually composed of two relatively straightforward ideas. The first is that Wisconsin's navigable waters belong to all of us. They don't belong only to waterfront property owners. They don't belong to corporations. They don't even belong to state government. They belong to the people. The second idea is that the state has an ongoing responsibility to protect our waters for the benefit of current and future generations. Those two ideas, that Wisconsin's waters belong to the people and that the government is obligated to protect them, have a direct impact on nearly every aspect of life in Wisconsin. The public trust doctrine protects our ability to fish, to paddle, to boat, hunt, swim, and much more. It helps safeguard the water quality and healthy ecosystems that make those activities possible. And it ensures that future generations will inherit Wisconsin's water resources, not in whatever condition we leave them, but with the protections that our Constitution provides for. Tonight, we'll explore how the public trust doctrine is being tested in 3 different cases that MEA is involved in. At first glance, the 3 cases may not seem to have much in common. One involves public access to the Lake Michigan shoreline, one involves climate change, and one involves an oil pipeline. But at the heart of each of these cases is the same fundamental question, and that is, what does it mean for the state of Wisconsin to act as trustee of our waters for the benefit of the public? That question is one that courts are being asked to answer today, and the answers will shape Wisconsin's environmental future for decades to come. Now, before we dive into those cases, though, I would like to spend a few minutes talking about where the public trust doctrine came from and why it remains such an enduring part of Wisconsin law. Tony, you can go ahead and share your screen. The origin of the public trust doctrine goes back about 2,000 years to ancient Rome. Roman law recognized that certain resources, like the sea, the shoreline, and flowing water, could never truly belong to any one individual. They were considered common to everyone and held for the benefit of all. That same basic idea influenced English common law, found its way into the Magna Carta, and later into the Northwest Ordinance. The Northwest Ordinance established the basic governing principles for the territories that would eventually become states like Wisconsin. When Wisconsin became a state in 1848, those principles were written into our state constitution. Next slide. Article 9 of our state constitution declares that our navigable waters shall be common highways and forever free. The Wisconsin Supreme Court has repeatedly affirmed that the state is the trustee of our navigable waters and that this role carries an affirmative duty to protect those resources for the public. Over the years, next slide, the public trust doctrine has remained relevant because Wisconsin courts have interpreted it to protect not only navigation, but many of the uses that make our lakes and rivers so central to our lives. They have recognized that those uses depend on healthy waters, water quality, aquatic habitat, and the ecological conditions that sustain our lakes and rivers are all essential to making our public rights meaningful. Our understanding of what it means to protect Wisconsin's waters continues to grow as new challenges emerge. Tonight, we'll explore some of those challenges. We'll have at the end of the webinar tonight about 10 minutes or so for a Q&A so we can answer some of your questions. So you can submit a question at any time during the presentation using that little Q&A feature at the bottom of your screen. Okay, let's get started. I am now going to turn it over to MEA Senior Staff Attorney Rob Lee, who will tell us about the first case.
Well, thanks so much, Peg, and thanks to everybody who is here in attendance and interested in this topic. What a privilege and awesome responsibility we have here at MEA to protect our public trust doctrine and advance it where necessary. So, first case study I have is a case called the Village of Shorewood v. Paul Florsheim, and that case is about public access to the Great Lakes shoreline. So MEA represents Paul Florsheim, and he was ticketed by the Village of Shorewood for trespassing after he walked along the shore of Lake Michigan adjacent to private property. And while he was out of the water, he was below what's called the ordinary high water mark, and therefore not on private property. But he got a ticket all the same. So let's get into it a little bit and discuss what's happening here. Tony, would you advance the slide for me? Okay, so here we have a picture that I took just a couple of weeks ago of the location where Paul was walking and cited for trespassing. I mean, you just have to look at it. It's not all that different than stretches of beach up and down the coast, right? And while Paul's case is about more immediately about him and this stretch of beach. It's also about all the other beaches, that people have come to love and enjoy right. Just look at it. It's a gorgeous place through there and on that beach. So. And I did try to do this webinar live from this location, but I was shot down for quote unquote logistics. But I suppose I digress. But talking about the ordinary high water mark, if you look closely enough, you can actually see really where it is on this beach, and it's back up. Not that those immediate bushes there, but back up. If you look at the tree on the left there, you can see where the sand goes. And that's what the ordinary high water mark is. It's that place on the bank of a waterway where there's usually a visual indication of, through erosion, vegetation, etc., of how high the water ordinarily gets. And this is crucial on the Great Lakes because adjacent landowners' property stop at the ordinary high water mark. Unlike our rivers and streams here in Wisconsin, landowners adjacent to lakes do not own the land underneath that water or beyond the ordinary high water mark. On the contrary, one way the state acts as trustee of our public trust waters is to hold title to land under our natural lakes, including the Great Lakes, to hold title in trust for the people. And that title starts at the ordinary high water mark, regardless of whether it's covered in water at any given point in time or not. But the point is this: Paul was on publicly owned land. The court in his case did not find that he ever went onto the real property of a private person or entity. They found that he was below the ordinary high water mark the whole entire time. But still, not only was he cited for trespassing, he was convicted in a municipal court for trespassing. So just think about that for a minute. The public being cited for trespassing on land that the people reserved for the public when this state was formed, land that the state owns in trust and cannot alienate for that very reason. And it boggles the mind a little bit, but let's explain. How is this possible? Tony, let's advance the slide. It is possible because of a case from 1923, a Wisconsin Supreme Court case. And the municipal court found that this case was binding and controlled its decision making. And from it, we get what the so-called feet wet doctrine. And this is the idea that you must be in the water, not just below the ordinary high water mark. You must be in the water to lawfully engage in public trust uses. And in short, the Supreme Court said that a landowner adjacent to Lake Winnebago could maintain an action for trespass against an individual for essentially doing what Paul did. And the court found that walking the beach was not navigation or wrapped up in any incident there too. Now Damel, this case, Damel v. Jantz, it's been cited a few times since it's been decided, but it's never really been revisited more than 100 years later. But Paul's ticket provides an opportunity now for the courts to do that. I think more importantly, though, it was Paul's willingness to stand up and fight against against this ticket, and against the idea that a riparian landowner could exclude him from public land. These issues wouldn't be coming to the fore, I don't think, if in part Paul hadn't stood up. Maybe you've seen issues popping up in other areas along Lake Michigan. There's been recent coverage of some landowners putting up a barrier and trespassing signs up by Lion's Den, south of Port Washington. Anyway, so Paul getting a ticket, willing to fight it, it does allow courts potentially to reevaluate Dame. And particularly in light of all of the public trust jurisprudence that has developed in the last century, both in Wisconsin and in other Great Lakes states. Tony, you can take this down for a minute if you want to, and I'll just talk to the good people for a minute. But I will say the public trust jurisprudence has developed significantly since statehood, right? And an important aspect of our public trust doctrine is that it is not stagnant. Our understanding of the rights that it has granted us evolve over time to reflect how people actually enjoy and use public trust waters. It's decidedly not stuck in 1848. If so, all we could do is float logs down it for commercial purposes. But as Peg said, it's expanded over time, or our understanding of it has expanded over time, right? And that it's always included all of those uses. And one that Peg, I don't believe, mentioned that's also important to Paul's case, that's been more recently recognized than the others, is enjoyment of scenic beauty. So, another thing I want to point out beyond just what's developed here in Wisconsin is that other Great Lakes states like Indiana and Michigan have also recognized a right to walk the beach below the ordinary high water mark through their court decisions. Now, we think the Damel Court just flat out got it wrong. We don't think it did then, and certainly does not now reflect how people use and enjoy our public trust waters. And this is not an attempt to take anything away from people who own land next to the Great Lakes. The term of art there is called riparian or a riparian landowner. They retain a whole host of rights to protect their property, right? And their rights to access the water from their property. But those rights are subject to the paramount rights of the public to enjoy our public waters. And what greater public water than our Great Lakes, including Lake Michigan there. So in this way, riparians don't lose anything. They can still build a pier. They can still make sure people don't come above the ordinary high water mark through posts and things like that. But what they don't have a right to do is exclude the public from public land. They've never owned the property below the ordinary high water mark, and it's not a part of their backyard. They bought that property subject to the paramount rights of the public enshrined in our state constitution, and no amount of money can overcome this. Our public land, our public trust waters, the Great Lakes are not for sale. So MEA very much looks forward to defending Paul as this case works its way through the courts. But I'll leave you with this. It's more even than just about access to and walking the beach. I view it as a stress test for the public trust doctrine to see if it's going to continue to live up to that broad and beneficent spirit in which it was always intended for the people. So, this is an effort in this area to reset that balance rather than in favor of the riparians where it always should have been, and in favor of the public and ensuring that our Great Lakes do remain forever free. Thank you.
Thank you, Rob. MEA Climate Justice Fellow Skylar Harris is now going to tell us about our next case.
Thank you, Peg, and good evening, everyone. As my colleagues mentioned, Article 9 of our Constitution, otherwise known as the Public Trust Doctrine, is broadly written to ensure that the navigable waters of our state remain forever free, and they impose a duty upon the state to protect that right in perpetuity. I'm here to talk about a case called Dunn v. PSC, in which 15 youth from across the state of Wisconsin are alleging that the state has failed in its duty to protect our navigable waters because it has failed to protect it from climate change. The broad language of Article 9 was written to ensure that the state had broad powers to ensure that our evolving uses and the involving encumbrances upon our navigable waters could be protected and protected against. So what is happening with the PSC is that they are in control of regulating the utilities across the state. This includes gas-fired power plants and various such other infrastructure. And there are two sets of laws. The first we colloquially call the CPCN statutes, and the second we call the RPS statutes. CPCN stands for Certificate of Public Convenience and Necessity. And in issuing these certificates to utilities, the PSC has to do what's called a public interest determination. And there are a variety of factors that the PSC can consider in those determinations, one of which includes environmental factors. However, because of laws passed by the legislature, the PSC is explicitly excluded from considering things like air pollution, which obviously impacts climate change. Under the RPS statutes, otherwise known as the Renewable Portfolio Statutes, or standards, I should say, the PSC is prohibited from requiring utilities to get more than 10% of their energy from renewable resources. Both of these sets of statutes prohibit the PSC from really engaging with climate change in a meaningful way and ensuring that our climate is best suited to protect the public. And that includes our rights in navigable waters. As many of us probably know, climate change has a severe deteriorating impact on our navigable waters. We have increasing flooding, warming water temperatures, decreasing ice and snowpack, impacts to cold water fishes and other animals that rely on those ecosystems. And so those harms to those waterways also harm the youth plaintiffs in this case. And I am going to present to you four of those plaintiffs, or four groups of those plaintiffs, I should say. Tony, if we could move to the next slide. So our first group is the Champagne family. It is Wazakone, Mukademiguan, and Gakuns, and their brother Tyler. And they are a native family living in Milwaukee, and they rely on our navigable waters for a variety of cultural uses. This includes things like growing wild rice and fishing sturgeon, and engaging in traditional cultural practices. And so one of the ways that the legislature and the PSC have failed to protect our navigable waters is by allowing them to warm due to climate change. And so warming causes, two separate harms. First is algal blooms. These are harmful development of green algae that can cause a variety of health harms and significantly impair waterways. The second harm is the warmer temperatures are impacting aquatic life. And so those are the major causes of the harms that the Champagne family are experiencing. So because of warming water temperatures, they've lost access to traditional fishing, like fishing for sturgeon, as I mentioned, and they're losing their ability to continue to grow things like wild rice. And so these harms to our navigable waters are causing harms to them, like harm to their physical and mental health, because they can see the world around them changing, and they understand that in the future they might not have access to the traditional resources that their people have relied on for thousands of years. And that is really detrimental to their mental health. Again, like I mentioned, disruption of cultural practices and access to traditional food sources. One of the things that they brought up when we first met them was their ability to play a game called Snow Snake, in which at a certain point at the beginning of the year, around February, they typically get together with their tribe and members of their family to play a cultural game. And because of the loss of snowpack and warming temperatures overall, the amount of snow has reduced in Wisconsin. And so they're no longer able to engage in that cultural practice. Those are the kinds of things that we lose when the PSC and the legislature fail to protect our navigable waters. Next slide. So the second person I'll talk about is Ted Schultz-Becker. Him and another plaintiff of ours named Charlie are both involved in agriculture. One does more animal-focused agriculture, and the other is more involved in crops. But both of them have seen severe harms to their families' small farms because of changes in precipitation. So this is both increased flooding and increased drought. On the side of increased flooding, it especially impacts them at the beginning of the growing season when they've just planted crops, because increased rainfall in the earlier months can lead to flooding out of seeds and the destruction of entire fields of crops. in the drier parts of the month, or of the year, I should say, they have the opposite issue where now their plants are not getting enough water. And so that has meant that they have had to install additional wells on their properties, which has caused them thousands of dollars in economic damage. They're losing amount of crop yield, which means they're not making as much money year over year. They're losing the ability to feed their animals, and the way that they have to house their animals is changing. So it has been really detrimental to the way that their family has made their livelihood. And this is something that Wisconsinites all over the state engage in, and have for hundreds of years. So not only is this a harm to them as plaintiffs, it's, a much broader harm that people experience. So, as the change in precipitation is occurring, we see harms to mental and physical health. Again, they don't know if they're going to be able to continue their family's traditional practices. So they are really feeling insecure about their futures and their ability to continue farming in the state. There's also the damage to homes, property, and farms. As we've talked about, increased flooding, as well as things like hailstorms, and other things cause immense damage and can cause economic harm as well. And then again, as I mentioned, disruption of cultural practices. Uh, Farming is a culture here in Wisconsin. It's deeply embedded in our state's history. And the loss of that has severe negative impacts, not just for the economics of the state, but for everyone that lives within it. Next slide. Talk a little bit more about increased flooding. This is our lead plaintiff, Karina Dunn. She is from the western half of Wisconsin, and in her childhood home, they were experiencing extreme flooding close to the Mississippi River. And at one point, a rainstorm completely flooded out her driveway, and it kept her from accessing her home for a period of 2 days. In addition to this, they've experienced a lot of other harms stemming from climate change, like erosion, that have put their families' lives and continuing health at risk. And because of these impacts, Karina was forced to move, I believe in the middle of her sophomore year of high school, to about an hour away from where she lives currently, which was a significant distance from the friends that she had grown up with and the family that she lived with. And away from the childhood home that she really thought she would grow old in. So again, this isn't just another demonstration of immense mental health harms to her and to her family, physical risk to her safety and her family's continued ability to live in their home, as well as continued economic harm because of the fact that they had to spend the money to pick up and move their entire family from where they've spent most of their lives. Next slide. And then this is the final plaintiff that I'll speak to you about tonight. Her name is Lucy Wright, and she is experiencing harms from declining winter snowpack. So Lucy is a competitive cross-country skier. She often competes in things like the Birkebein and other national competitions. But over the last few years, there has been a severe decrease in snowfall up in northern Wisconsin where she lives. And this has really impacted her ability to engage in her sport. And it's gotten to the point where first she lost her school team, and then her, competitive travel team had to start traveling more than 2 hours in order to access fake snow in order to practice on a small loop, as opposed to practicing in nature. To this year, where she has decided to permanently leave her cross country ski team because she no longer feels like it is worth it to spend the time because she no longer has access to the snow necessary to practice. Most of her practice for the last few years has been dry land almost exclusively. And she really prefers to be able to ski in the snow. And she's really lost the ability to do that. In addition, she often teaches kids and others in her community how to ski on local trails. And because of the loss of snowpack, she has not been able to really engage with her community in the same way. So in that way, it's the harm to her physical health because she's no longer able to engage in the same kinds of exercise and recreation that she is used to. It's a harm to her mental health because she's losing that community. She's losing her ability to practice her favorite sport. It's a disruption of her cultural practices. Her family is a Nordic family. They've lived here for hundreds of years and multiple generations. And since, their family's beginnings in Wisconsin, they have always engaged in skiing, especially in cross-country Nordic skiing. So this is really a loss to her family specifically and the cultural practices they've always engaged in. And then because of the loss of snowpack and because of the fact that we still engage in sports like skiing and snowboarding as recreation in the winter, and they are large sources of tourism, towns like those that host the Birkebeiner are forced to bring in artificial snow, which increases the cost of these competitions by millions of dollars. And the loss of snowpack overall decreases the tourism to the area. So it's not just an impact on the people who participate in the sport, but it's an impact to the culture and to the community overall. So as you can see from these examples, and there are many more from, the 15 plaintiffs overall that we are representing here, the legislature and PSC's duty to protect the public trust is core to many of the values that we hold here in Wisconsin and many of the ways that we spend our everyday lives. Without that guarantee of protection for evolving harms, not just the harms that existed back in the 1800s, but the ones that exist now and that are harming our navigable waters every moment that we sit here with one another, we continue to lose our ability to retain who we are as Wisconsinites. So I think it's really important that we recognize how broad the public trust doctrine really is and the ability that it gives the state to protect our navigable waterways. And it's our duty to ensure that they continue to do so. Thank you.
Thank you, Skylar. Our next speaker is Anya Jansen. Anya is MEA attorney for Native Nations Partnerships. And I'm going to hand the mic over to you, Anya, and we're looking forward to hearing about the next case.
Thank you so much, Peg, and good evening to everyone. Our Line 5 litigation is a third example of how MEA is interacting with and working to enforce the public trust doctrine. And Tony, if you could advance to the next slide, please. So some of you may be aware that despite the fact that our litigation is still ongoing, Enbridge has actually begun construction on this controversial oil pipeline reroute through northern Wisconsin. And in order to complete this construction project, there are numerous navigable waterways that Enbridge would need to cross, and all of these waterways are protected under the public trust doctrine. These water bodies are some of the most pristine in the state. Communities depend on them for public trust uses like recreation, hunting and fishing, navigation, and just enjoying the overall scenic beauty. Now, if this image on the screen feels overwhelming to you, it really should. This image was created by the Great Lakes Indian Fish and Wildlife Commission. It shows the hundreds of interconnected waterways that would be impacted by this pipeline reroute, and really just kind of shows how devastating in scope the project truly is. So the waterway crossings for this project would involve placing structures on, depositing materials into, and using explosives to blast through bedrock of navigable waters. These construction activities will inevitably harm, and in fact have already harmed, public trust waters. On top of that, members of the public, including MEA's clients and tribal members, would no longer be able to use or even access the public trust resources within the vicinity of the pipeline without facing a felony trespass charge. So for these and other reasons, The permit authorizing construction activities in these navigable waters violates the public's constitutional right to the public trust resources, and that is why we are fighting to get it invalidated. So I'm going to spend the next few minutes telling you more about the reasons why and the resulting impacts to the surrounding communities. Next slide, please. The state law that authorizes the Department of Natural Resources to permit construction activity of this sort in navigable waters is specifically designed to protect the public's interest in those same waters, meaning it's the public's interest, not the interest of a foreign oil corporation, that must prevail. And that is really the nature of constitutionally protected rights. Now, remember that DNR has been delegated the duty as trustee to protect Wisconsin's public trust resources for the benefit of the people. So when making these kinds of permit decisions, if the department is presented with concrete and scientific evidence that the state's public trust waters would be harmed by a proposed construction project, then DNR must deny that permit. Next slide, please. Here, MEA, on behalf of our clients, Sierra Club, League of Women Voters of Wisconsin, and 350 Wisconsin, jointly with Clean Wisconsin, we did just that. We presented concrete and scientific evidence during the course of a 6-week hearing with several expert witnesses that the reroute would harm waters of the state and violate the public's constitutional rights to those public trust resources. We have countless legal filings available on our website where you can read all about those claims in detail. I won't bore you with those details now. The gist, though, is that the construction activities that I talked about earlier, they have already caused and will continue to cause serious damage to our navigable waterways. So as a result, if Enbridge is allowed to complete this reroute, members of our client organizations would no longer be able to enjoy their public trust rights to fish, to hunt, swim, paddle, enjoy the scenic beauty, and more in these waterways on account of the environmental degradation that Enbridge will cause. Unfortunately, DNR ignored these harms to the public trust waters and decided to grant Enbridge the permit for this project. Next slide. This was especially evident in how DNR permitted blasting in navigable waters. When you think about this construction activity of blasting, imagine the explosive devices placed on beds of navigable waters to quite literally blow up the bedrock in order to remove that material. That's obviously not something that you can ever put back together again. And as you might imagine, if you change the foundational makeup of the bed of a water body, that is going to forever alter how the water flows through it. We all know how interconnected water is. If you blast one bed and change the flow of one water body, that will very likely impact surrounding surface water. It could degrade the water quality. It could harm the wildlife that live in and depend on those water systems. And all of these environmental factors are crucial and directly support public trust uses that our clients enjoy. To this day, even as construction has begun, neither DNR nor Enbridge knows every single location where blasting will be necessary. And to grant a valid permit for the removal of material from the beds of navigable waterways, DNR must make a site-specific determination that the permit issuance will be consistent with the public interest in every water body to be impacted. In other words, DNR needs to examine each water body, determine what the public uses are in that water body, and then ensure that the permit would not be inconsistent with those uses. And that is plainly not possible when the very identity of each water body where blasting will be required is unknown. So for instance, Many members of our client, the League of Women Voters of Ashland and Bayfield counties, they live near and they regularly swim, fish, paddle in particular water bodies to be crossed by the pipeline where blasting may occur. What DNR needs is the location of each and every water body where blasting will occur in order to assess whether blasting would impair those rights to swim, fish, and paddle in those water bodies before it can issue the permit. Issuing the permit without that specific public trust determination, which is what DNR did here, is illegal. Tony, next slide, please. Taking this one step further, as I previewed earlier, our clients won't even be able to use or access the waters within the larger area that Enbridge needs to maintain the pipeline. And this is because of Wisconsin's so-called felony trespass law. This law makes it a felony to enter an energy provider's property without the energy provider's consent. So when you think about that, the reality here would be that members of our client organizations, along with tribal members, would need to seek Enbridge's permission to swim, hunt, fish, paddle, etc., in water bodies that they otherwise have a constitutional right to. Without Enbridge's permission, they would be risking a felony trespass charge to engage in these public trust activities, and that is simply unacceptable. Last slide. Our clients commonly access these public trust waters impacted by the reroute, and they regularly engage in public trust activities like I've been mentioning. This is their constitutional right. Any deprivation of those rights is unlawful, and that is why it is one of the central claims driving our Line 5 litigation. Now, there's good reason why so many Indigenous communities hold true this concept that water is life. Waters of this state are the lifeblood of the land. They give life to all living beings. So it's no wonder that these waters are given special constitutional protections. DNR really has been entrusted with a duty that is as sacred as it is legal, to protect these public trust waters. Here, what DNR has functionally done is to impermissibly hand off that duty and responsibility to Enbridge, which again is a foreign oil corporation. To say the least, this is an affront to all residents of this state for whom our public trust waters are supposed to remain forever free. So I know that I can speak on behalf of all of MEA when I say that it is the utmost privilege to represent our clients in this matter and to work to ensure that the public trust doctrine is enforced and that these public trust waters are protected. Thank you so much.
Thank you, Anya. All right, we have about 10 minutes or so to take some of your questions. But before we do that, I want to say that if you'd like to learn more about any of these cases, any of the cases you heard about tonight, please visit our website, midwestadvocates.org. Lots of great information and resources are available there. While you are there, you can sign up to receive our monthly newsletters, and you can even make a donation to support our work if you feel so inclined. Well, we've covered a lot in a relatively short amount of time. I guess I hope that one of the things you take away from the program is that while the public trust doctrine is powerful, it doesn't enforce itself. Our rights depend on people who are willing to stand up, to ask hard questions, and to insist that our government fulfill its constitutional responsibilities. And it's the role of Midwest environmental advocates to stand alongside them and to provide the legal services and the resources that they need to succeed. Many of you in the audience tonight have helped to make that work possible, and please know that we are grateful for your support. With that, I'm going to turn it over to Tony, who will moderate our Q&A.
Thank you so much, Peg. We have some great questions from folks. We appreciate those questions. Let's start with this one from Richard Phillips. He notes that there are 3 pending lawsuits in Wisconsin where wake surfers are challenging local ordinances prohibiting wake surfing on lakes within their jurisdictions, and they're challenging those ordinances under the public trust doctrine. And he asks whether we have any comments about these private individuals using the public trust doctrine to prohibit towns from enacting these ordinances, which are based on environmental and safety concerns. He notes that the ordinances don't prohibit the boats themselves. They prohibit the activity. Yeah, what are our thoughts about this? Any comments?
Well, I'll just initially say that to some extent, like the DNR, the legislature has delegated some authority over navigable waters to local governments. Of course, DNR's authority there is paramount, but there is some authority to regulate things there. Now, how far that goes, it sounds like it's a question in these lawsuits here. But I think with wake boats in particular, what we're talking about here is competing public trust uses. Sure, maybe the use of a boat and even wake surfing, and which I take as the whole point of the wake boat, right? And all of that is a public trust use. It's recreation and all of that. But it also has an incredible impact on other public trust uses if it's not done in the right locations. My understanding is that certain water bodies aren't very conducive to wake boating, and that it can actually, if it happens too much, destroy other public trust uses. So when we have a competition there between public trust uses, whether it's a town or DNR or the legislature itself coming in as trustees of that, there likely is some authority to try to strike the balance as it makes sense with the water body. What we can't have is us destroying all the vegetation and wildlife and water quality by one use being run rampant, right, to the detriment of all the others. So our comment there is really about balance, and that not all uses may be appropriate on all water bodies.
Thanks, Rob. Yeah, I think that is well said. Because we've got a number of questions that are coming in, maybe we'll just go to the next one. So someone asked about the ordinary high water mark access and whether that applies only on lakes and not rivers and streams. Can we maybe say a little bit more about the difference between lakes and rivers and streams?
Yeah, I alluded to it very quick. And in fact, I was running long like I always do, so I skipped over part of this in my initial presentation. The issue of access to the exposed shore, right? You're out of the water, but below the ordinary high water mark. It's slightly different on rivers and streams because riparian owners do own the land to the center of rivers and streams, which is, as I explained earlier, different than lakes. That said, the ordinary high water mark still plays a role, or at least it should, right? Because, even applying the keep your feet wet doctrine, as long as you're doing that and keeping your feet wet, you're supposed to be able to do so up to the ordinary high water mark. Well, and actually there's a case about right now about what happens when there's extraordinary high water mark. So it does play a role, and it does influence things, but it's just different than what we're talking about in Paul's case on lakes and the Great Lakes specifically. And the final thing I'll say, which is just so interesting here, is that Wisconsin statute actually recognizes more of a right to access the exposed shore of a river and stream, even though riparians own that land, than on the Great Lakes. There's a law That says if there's an obstruction in your river and stream that you're walking by, you can get up out of the water and walk the exposed shore to get around that obstruction. There is not a similar provision for our Great Lakes. So we actually have greater recognized rights to access at rivers and streams in the Great Lakes. So make it make sense. It doesn't right now.
Thanks, Rob. Yeah, and I'm just thinking about the fact that our state constitution protects not only the waters, but the carrying places in between. So yeah, you have a right to navigate around obstructions. That's reflected in statute, and it has a constitutional significance as well. Um, Jackie Boynton asks a really great question here that I think would be great for us to go over with everyone. So, what is the status of each case that we've talked about? Where are we in the process? Maybe we'll start with line 5. Anya, do you want to take that for line 5?
Sure. So right now we are in a proceeding for judicial review before circuit court, where we're asking a circuit court judge to review the decision of the administrative law judge, and that affirmed the DNR's decision to permit the line 5 reroute. So we briefing is done in the proceeding for judicial review. We have oral arguments scheduled for August 20th, and we will hopefully get a decision on the merits by the judge soon thereafter. And then from there, of course, any party has the right to appeal to higher courts, depending on how that decision comes down. And we will obviously follow along and take appropriate legal action accordingly.
Thanks. Anya, Skylar, you want to give us the status of Dunn v. PSC?
Yeah, so we filed our case in August of 2025. Unfortunately, that case was dismissed by the circuit court judge in Dane County underneath what is called the political question doctrine. And we feel that that decision is incorrect. So we are appealing the case. We filed the appeal a couple of months ago, and now are in the process of writing our opening brief.
Thanks, Skylar. And Rob, Florsheim v. Shorewood or Shorewood v. Florsheim?
We are in front of the Milwaukee County Circuit Court, Judge J.D. Watts right now, and the case has been briefed, and there's a hearing in the matter on August 13th. Perhaps we'll get a decision from the court then, or soon thereafter, and we'll go from there, a potential appeal up to the Court of Appeals. But certainly, first things first, we need a decision from the Circuit Court.
Excellent. Well, I know that we've answered some of the questions in writing through the Q&A feature, and there are a few more that I don't know that we'll have time for, but maybe we can try to follow up with those folks over email. Well, I want to close us out by just thanking again everyone for joining us. This is one of our just most attended webinars, one that folks have been talking about. So we're really appreciative of all the interest and the support with these 3 cases that you have shown us as MEA's friends and supporters. And as my colleagues have said, it is a real privilege and honor to get to do this work. And many of you here tonight allow us to do that. We're so grateful for that. Again, thanks for taking some time this evening to learn about these cases and to spend some time with us talking about the public trust doctrine. Thank you.